Hello, everyone. I'm Brian Patterson. This is ENS Africa, and it's my pleasure today to welcome you to the first in a series of ENS Africa webinars on employment law. Today, we are going to focus on hiring and firing in the African continent, and I will moderate further webinars in due course, which will deal with other issues such as redundancies, retrenchments, reductions in force, as they're called in the United States, or RIFs, GDPR, PAPIA, also transfers of businesses in the UK. They call it as the TUPE regulations, and in South Africa, Section 197. I'm hoping that these webinars will be on a monthly basis. We're very excited today because we've had more than 300 participants join us today throughout the African continent, and a large number of participants from the United States, Ireland, the United Kingdom, and the rest of Europe. The panel consists of colleagues of mine in various offices of ENS, and I'll briefly introduce you to them. The first panelist is David Sidu, who comes all the way from Accra, Ghana.
Hello, everybody. Great to be here today. Thank you.
Hi, David. And then Faith Chabet of Nairobi, Kenya.
Hello, everyone. Pleased to be here today, and thank you for joining us.
And Kenya as a jurisdiction, as you all know, is seeing remarkable growth at the moment. So we're really looking forward, Faith, to hearing about employment law in Kenya. Then we have Charles Visser from Windhoek, Namibia.
Good day, everyone. It's a pleasure being here this afternoon.
And also we are pleased to see Ray Wood-Rakuru of Walvis Bay, also in Namibia, is joining us on Namibian hiring and firing.
Thank you very much for having me. Good afternoon.
And Eustace Ngoga from Kigali, Rwanda, our Rwandan office.
Hello, everyone. It's a pleasure to be with you. Thank you.
Thanks, Eustace. And Audrey Johnson from Johannesburg, South Africa.
Hi, everyone. I'm very excited to be part of this webinar and look forward to chatting to you.
And finally, and certainly by no means least, Rachel Masuko from Kampala, Uganda.
Hello, everyone. Thank you very much for joining us.
These are all lawyers who are expert employment lawyers, and I'm sure this afternoon we'll unpack at a very high level and punchy webinar, I'm hoping, the key aspects of hiring and firing, and be able to do a comparison between the jurisdictions. So it's going to be quite exciting. I want to mention a few preliminary points. First of all, the law in relation to these jurisdictions has some similarities. There's no employment at will. Now, David will correct me because Ghana is an exception. I understand statutorily there is employment at will, but not in practice. So David will tell you about that. But for our US colleagues and friends, you won't be surprised to know there's no employment at will. Also, we're covering a whole variety of jurisdictions, from Roman Dutch law to English common law to Lusophone and Francophone, although we won't focus on Lusophone and Francophone today. So a lot of different legal systems come in play. Then a number of my colleagues from law firms have texted me during the week and asked, will we cover certain issues? And a number of them have said, what about compromise and settlement agreements? Can I avoid having to deal with the law in Ghana by just simply short-circuiting everything and doing a compromise settlement agreement? Our panelists will deal with that in their presentations. And a number of our colleagues have also asked me, well, what about senior management executives and directors? Is there any special provisions that apply to them? Again, we'll touch on these. And a lot of US colleagues have said, okay, what happens if we want to terminate someone and we don't want to follow any procedure, whether lawful or fair? How much will it cost us? And I'm sure many have faced that question, and it's one that our panelists will address. So if you have questions, submit them to the Q&A, and I'll moderate a Q&A session at the end. after the 1 hour. We've allowed 10 minutes. If we run out of time, what I can give you an assurance is that each of the panelists will come back to you on those questions and provide you with high-level advice. So without further ado, I'm going to hand you over to Audrey Johnson, who will deal with hiring and firing in South Africa. Audrey.
Thanks, Brian. So I thought a good starting point, I mean, without in any way professing to be a corporate lawyer or a tax expert, and that's not the ambit of this discussion, but I just wanted to highlight as a starting point that if you are someone who is considering coming into South Africa for the first time and wanting to do business in South Africa for the first time, and you're considering hiring people in South Africa, the first critical thing that you would have to decide is what sort of corporate setup would you use to do business in South Africa. So as I've said, that's very much more a corporate question and a tax question, because you have to consider things like whether or not there's a risk of a permanent establishment being created. You have to consider the number and type of employees that you're going to have in the country. But just very briefly in general, the options range from using someone in South Africa that is not an employee, that's an independent contractor, or that is supplied to you by an employer of record, so you're not actually the employer, or establishing a proper local entity in South Africa, which would then have to comply with all of our company laws, and that would obviously be subject to strict regulation, and that would only be suitable if the business that you're planning on doing in South Africa is extensive. So that would be the first issue that you'd have to consider when looking at hiring employees in South Africa. The second important issue is obviously what type of employment contract should you use. So there's a variety of different types of employment contracts that are permissible in South Africa. Each have their own idiosyncrasies and each have their own risks and their own benefits. These also have to be very carefully weighed up and considered. And the most important thing is to consider the reason why you are employing this person and what they're going to be doing to determine what sort of employment contract is appropriate for them. So the first issue is, what is the duration of the employment contract? Do you employ someone on an indefinite period contract, or do you employ someone for a fixed term? The use of fixed term contracts is highly regulated in South Africa, particularly for employees that earn below an earnings threshold that is determined by the Minister of Labour in terms of their Basic Conditions of Employment Basic Conditions of Employment Act. That earnings threshold does change from time to time, but it's basically employees that earn below about 200,000 Rand per annum, so very low earning employees. And the regulations in relation to employing employees on fixed term contracts when they earn below that level are there to protect employees from the abuse of fixed term contracts. So the Labour Relations Act provides that you can only employ someone on a fixed term contract if you have a justifiable reason for employing them on a fixed term contract. And generally speaking, you can only employ someone on a fixed term contract for 3 months, not longer. Although those regulations only apply to employees that earn below the certain earnings threshold, you also have to be careful when you use fixed term contracts for other employees, because our law does provide that if you rely on the expiry or the termination of a fixed term contract to end an employment relationship, and the employee can show that they had a reasonable expectation that their fixed term contract would be renewed, that could be an automatically unfair dismissal. Oh, sorry, that termination could constitute a dismissal. So then the contract wouldn't actually terminate as a consequence of the expiry of the contract, but in fact, they can allege that they have been dismissed and that dismissal was unfair. So that could be actionable. So you really have to consider very carefully whether it's appropriate to use a fixed term contract. And it would only really be appropriate if the person that you're going to employ is only needed for a defined duration to work on a specific project, or for work that is only required for a certain limited period of time. So if you can't justify using a fixed term contract, then the alternative is obviously to employ someone on an indefinite period contract. And as we'll see when we get to firing, an indefinite period contract is a bit more challenging, because you can only terminate an indefinite period contract if you have a fair reason and if you follow a fair procedure. We also have a distinction in our law, as in most jurisdictions, between an independent contractor and an employee. And our law follows a substance over form approach. So I think many employers think that they'll just use an independent contractor agreement, but the question isn't what the agreement says. The question is, what is the real substance of the relationship between you and that individual? So again, if you're planning on using an independent contractor agreement, you have to make sure that in giving effect to it and in implementing that contract, you actually treat the person as an independent contractor and not as an employee. Otherwise, if they can demonstrate in due course that they were in fact an employee, they are entitled to all the rights and protections that are afforded by the labour legislation. So that's also something that has to be carefully considered. And then, of course, there is also the option of using a labour broker, which is alternatively known as a temporary employment service. These are companies that are purely in the business of supplying labour. Again, something that is very highly regulated in terms of South African law, particularly for lower level and lower earning employees. And there are deeming provisions in our Labour Relations Act where in certain circumstances, the client of a labour broker or of a temporary employment service provider is deemed to actually be the employee of the individuals that have been supplied to it by the labour broker. And as a result of that, you cannot escape the consequences of our employment legislation in relation to those individuals. So again, you have to carefully consider whether or not using a temporary employment service or a labour broker is appropriate, and you have to manage the risks associated with those sort of relationships, those tripartite relationships as well. And the most critical thing there is to make sure that the agreement that you have with the labour broker contains all of the necessary protections and indemnities and warranties to ensure that you won't ultimately incur significant liability in relation to the use of labour broking employees. Then another consideration in terms of the type of employment contract is the amount of flexibility that you want in the employment contract in terms of hours of work. So it is completely permissible in terms of South African law to provide for totally flexible or 0-hour contracts of employment where you don't provide a guarantee as to any minimum number of hours of work that you are going to provide to that individual. This is often used in the sort of environments where it's very cyclical in nature. The levels of business change drastically during the course of the year, depending on various circumstances. And you may need someone to work up to 195 hours in 1 month, and in the next month, you've got no work for them. So it's seasonal work, basically. So in those sort of industries, it is permissible to use an indefinite period contract rather than a fixed term contract, but one that is very flexible in terms of hours of work and where you roster individuals to work depending completely on your business needs from time to time. Alternatively, obviously, you could have a full-time employee, a permanent full-time employee that works ordinary hours of work, your traditional 9 to 5 type of hours of work with a lunch break, and they then are guaranteed those hours of work, and you have to remunerate them usually on a monthly basis for those hours of work. So that's another consideration. It is, of course, completely possible as well to have a fixed term contract that is also flexible in terms of the hours of work that you are prepared to provide to the individual. So you could have a flexible fixed term contract of employment. Then finally, just in terms of hiring, the type of contract that you use has to be carefully considered in terms of what sort of provisions have to be in it or should be in it. And that, again, I think a lot of employers fall into the trap of just using standard employment contracts across the board, but there are certain provisions that you may want to include in different employees' contracts of employment that may not be appropriate for other employees. So, for example, whether or not you include a probation period. And a probation period in our law simply means that for a certain period of time, your notice period that you would have to give to the employee if you want to terminate is usually shorter, and you can have less compelling reasons for terminating, but you still have to have a justifiable reason. And during the probation period, you basically monitor and assess the employee's suitability for continued employment quite closely. A probation period is not suitable for all employees. It depends on the nature of the role. And also you have to carefully consider the duration of the probation period, because our law also says that the probation period must be reasonable to allow you to properly assess the individual. So you can't just have a one-size-fits-all probation period in all employment contracts. Then, of course, the issue of restraints. In our law, restraints are enforceable to the extent that they are reasonable. And whether or not they are reasonable depends largely on the extent of the restraint, so the area and the duration for which you are restraining the employee, but also importantly, the nature of the employee's role and the sort of information, proprietary, confidential, trade secrets information that they had access to during their employment, and whether or not you have a proprietary interest that's worthy of protection at the expense of the employee being gainfully employed elsewhere. So you have to carefully consider when you employ someone, whether or not it's appropriate to include a restraint in their employment contract to protect your business, but also whether or not that restraint would actually be enforceable. That then is coupled with a consideration of what the appropriate notice period would be, because in our law, it is okay to put someone on gardening leave during their notice period. And that would also be a way of sterilizing an employee that is about to take up employment with a competitor, to put them on gardening leave during their notice period. And so you have to consider, is it necessary to maybe provide for a shorter restraint coupled with a lengthier notice period during which I can sterilize this person by putting them on gardening leave? And of course, all of these things are usually appropriate for very senior managerial or executive employees who are going to have extensive access to confidential and proprietary information. So I think it's clear that it's very dangerous to just use a one-size-fits-all type of employment contract, or it's certainly not advisable. There's a lot of consideration that has to go into what type of contract you use when you're hiring individuals in South Africa, and what provisions you include and what provisions you don't include. And then just the last point on hiring in South Africa, obviously we do have this unique aspect in our law, given our history of apartheid, that we have legislation in place that specifically protects against unfair discrimination and places an obligation on certain employers to implement affirmative action measures. And that obviously has an impact on your hiring decisions and also on your hiring processes, because you have to be very careful not to unfairly discriminate against candidates for employment, because they are covered by the Employment Equity Act as well. So in your recruitment process, in your interview process, there's certain things you have to steer clear of asking applicants for employment and basing your hiring decisions on. And then in terms of your affirmative action measures, certain employers have to have employment equity plans in place where they have actually set goals and objectives for themselves to achieve certain targets in terms of having fair representation or equitable representation across all job categories of people from previously disadvantaged groups. So that would, of course, impact on the candidate that you ultimately select for positions. Okay, Hilary, I think we can go to the firing slide, please. Hilary, you can move to the firing slide.
Hi, Audrey. When Hilary's getting that firing slide, we just need to move a little quicker through that. Otherwise, it'll be over time.
Yeah. I do intend to be a bit shorter on firing, so let me go ahead with that. So as Brian mentioned already, in South Africa, we don't it's not an employment at will jurisdiction. So you can only terminate an employee's employment in South Africa if you have a fair reason and you have to follow a fair procedure. The procedure that you have to follow depends on the reason for termination. And of course, we don't have time today to go through all of the procedures in any detail. But the acceptable reasons for terminating an employee's employment in terms of our Labour Relations Act are basically misconduct. That's obvious, where an employee has broken a workplace rule or breached a workplace rule or breached their employment contract. The second is capacity, which can either take the form of poor performance. They're not capable of performing at the standard that you require of them, or they are incapable of performing because they are ill or because they're injured. And then the third is an operational requirements termination, otherwise known as a retrenchment, where it's basically as a consequence of a restructuring and declaring positions redundant. And that's a no-fault termination where the employee would usually receive would receive a severance package. As I've said, the procedure differs depending on what the reason is, But in essence, almost all of them, the operational requirement termination involves a lengthy consultation process. There are a number of items that you have to consult on in terms of the Labour Relations Act. Both the misconduct and the incapacity processes would involve giving the employee an opportunity to be heard before you make a final decision to terminate their employment. It's possible in our law to terminate an employee's employment summarily, so without any notice period, but that only applies in cases of serious gross misconduct. You know, something like an assault or theft or fraud, where there has been a material breach of the employment contract, you can terminate summarily. Otherwise, the contractual notice period provided for in the employment contract would apply. It is possible to pay an employee in lieu of their notice period so that their employment terminates earlier. Or alternatively, as I've mentioned, you could place an employee on gardening leave where they still remain an employee and they continue to receive their remuneration, but they're not required to come to work during that period. I have mentioned the use of fixed term contracts. The important thing to realize there is that a fixed term contract expires automatically on the termination date provided for in the contract. And that could usually be defined by time. So it would have an expiry date that is defined by time, or defined by purpose. If you employ an employee to work on a specific project, you could say that your employment will terminate when that project comes to an end. We don't know the exact date when that would be, but when that project is completed, your employment will terminate automatically. In those instances, there's no need to give an employee notice of termination because that expiry of the fixed term contract happens automatically. Of course, employers often run into problems when they allow an employee to continue working beyond the expiry of their fixed term contract. Similar issues arise in relation to retirement and age discrimination. So it is possible to provide an employment contract for an agreed retirement age, or an employer may have a normal retirement age that is determined by the rules of the retirement fund that the employees participate in. And often what happens is that employers allow employees to work beyond their agreed or their normal retirement age. And for a while, there were a line of cases in our law that held that it's unfair discrimination on the basis of age to dismiss an employee if they've reached their retirement age, but you've allowed them to continue working beyond their retirement age. And that's on the basis of a provision in our Labour Relations Act that says that it's automatically unfair to dismiss someone on the basis of their age. But that section in the Labour Relations Act specifically says unless they have reached their retirement age. And a recent Labour Appeal Court judgment has actually confirmed that based on the wording of that section, it doesn't matter if that termination occurs after the month in which the employee reached their retirement age. If they are at their retirement age, you can terminate their employment as a consequence of them having reached their retirement age, and that wouldn't constitute age discrimination. In relation to unfair dismissal disputes, employees can challenge the fairness of their dismissal either at our employment tribunal in South Africa, which is called the Commission for Conciliation, Mediation and Arbitration, or at the Labour Court. Which forum they go to depends on what the reason for their dismissal was. And the primary relief in South Africa, if it is found that an employee's dismissal was unfair, is actually reinstatement with unlimited back pay. So an employee can be put back into their position and the employer can be required to pay them their remuneration with effect from the date on which they were dismissed. That's the primary relief. In certain circumstances, if the CCMA or the Labour Court is satisfied that either the employee doesn't want reinstatement or reinstatement is not practical, then the relief that the employee could get is up to 12 months remuneration as compensation. And a judge or a CCMA commissioner deciding the matter has a discretion to decide how much compensation to award, and it depends on the extent of the unfairness. Brian did mention the possibility of concluding a separation agreement or compromise agreement. That is completely possible in our law. We do normally advise employers that the timing of when you initiate those sort of discussions, again, has to be carefully considered. There are risks associated with an employer initiating those discussions too soon. Obviously, it's also strategic. You want to sort of enter into those without prejudice discussions to settle or to potentially reach a mutual agreement with an employee at a time when you have leverage. And when the employee basically knows that the writing's on the wall and they would be better off potentially concluding an agreement with you rather than facing a dismissal. So again, each matter is different, but you have to consider carefully what the appropriate time is to enter into those sort of without prejudice negotiations. There's no regulation in our law dealing with senior managerial employees or terminating their employment. You do, however, have to be careful if you're dealing with a dismissal of someone who is a director, a statutory director, particularly if they have a contractual entitlement to be a director. Then you have to tread quite carefully, because you could end up breaching their employment contract if you terminate their directorship before their employment has been terminated. And obviously terminating their directorship has to be undertaken in terms of the Companies Act, but the order in which you do things then becomes quite important depending on whether or not they have a contractual entitlement to be a director or not. And I think that brings me to the end. I'm not sure how I did on timing. I don't think I set a very good example for my colleagues.
Thanks, Audrey. I think you've given us a very comprehensive review, so thank you for that. I think there are some Q&As, one for you, which we'll come to at the end. Let's move on without further ado to Chevron Darby of Mauritius. If you could briefly tell us about hiring and firing in Mauritius, Chevron.
Thank you, Brian. Hello, everyone. I'll wait for Hilary to, thank you, Hilary, to project my first slide, which is the next one. So I'll start in the meantime. So the recruitment process, the first step in hiring in Mauritius, the most important matter to take into account is to ensure that there is no discrimination at the time of recruitment, that is during the interview process. So once the main items on which there could be discrimination is that of gender, HIV status, nationality, and religious or caste considerations. There are three main types of employment agreements that a person could enter into. The main one, which is the most widely used one, is that of indefinite term agreement. This is the default position under our employment laws. Fixed term agreements, which are another possibility of employing employees in Mauritius, are usually, in most cases, available only for workers earning in excess of 600,000 rupees annually. In respect of those employees earning less than this threshold of 600,000 rupees annually, employees could be employed on fixed-term agreements only in respect of specific projects, or if ever they are replacing one employee who is on leave. In terms of casual workers, these are workers that are usually used in specific industries, for instance, tourism during the high-end season and agriculture during the harvesting season. It is possible in certain circumstances to employ contractors, but like in South Africa, the test is one of substance and not limited to the contractual terms between the parties. So it will be necessary to ensure that the actual way in which work is carried out is in fact that of a contractor and in principle. And the cornerstone of that test is that of control. Now, when you are employing in Mauritius, irrespective of the type of contract that you use, the most important factors to bear in account is firstly, whether or not you are employing that person in a regulated industry, for instance, in financial services or in banking, for senior personnel especially. You would need to ensure that they pass a fit and proper test. And in that respect, you may need to consult the regulator to obtain the approval of a regulator, whether the Financial Services Commission or the Bank of Mauritius, to ensure that the person obtains the fit and proper approval from the regulator. Secondly, obviously, if you are employing a non-Mauritian, a non-resident in Mauritius, you would need to ensure that all visa requirements have been fulfilled. This in turn means deciding whether you will sponsor that person to allow the person to obtain a visa in Mauritius. In Mauritius, I would like to point out this may not be a particularly cumbersome procedure. It's a procedure that takes around 6 to 8 weeks to be completed. In terms of your contractual terms per se, you need to have a written agreement whereby the basic terms and conditions are provided for. So these are the job title, the main duties and responsibilities, the commencement date, the salary, the place of employment, and the category of a worker within the organization. In more elaborate employment agreements, you would need to ensure, for instance, if the person is likely to be seconded to another jurisdiction, even if not seconded immediately, but is likely to be so seconded in the future, you would be well advised to include a term in your contract to allow for a future secondment. It is also customary in Mauritius that employees within one organization are called upon to carry out tasks in respect of another organization, but within the same group of companies. So here as well, you would be well advised to include this obligation towards group companies and the possibility that the worker, the employee, be called upon to provide these services to other entities within the same groups. Probation, it's an essential part of a contract, because if well drafted, the probation clause may allow you to terminate earlier than usual if the probation period is not satisfactorily completed. Everything in respect to confidentiality, notice periods. Once probation is completed, notice is expected to be of at least 1 month. All consents in respect of data protection, like I mentioned earlier on, in respect of sharing of information to group companies, ability to change location, which is closely linked to secondment, and duties towards group companies. So this is in brief the main terms that you would wish to include in your employment contract. So one last one would be the post-termination obligation in terms of restraint of trade. These are fully enforceable under Mauritian law. They need to be limited in time and space. They need to be absolutely necessary to protect the legitimate interests of the employer, and that interest needs to be identified. In Mauritius, there's no need per se to provide for a financial compensation. And once again, you would be well advised to take into account the fact that the employee may have provided services to other group companies, as well as to companies which may be outside of Mauritius in case of secondments. So this concludes my part on hiring in Mauritius. So Hilary, if you could move on, thank you, to the next slide. So, which is a firing slide. So in terms of fixed term agreements, they come to an end automatically without any need for any formal process or notice to be served. However, once again, you would be well advised to ensure that the employee does not continue to perform beyond the expiry date. If that's the case for long enough, it could well mean that the employment contract has been tacitly renewed. And whenever there's a tacit renewal of the employment agreement, the duration becomes an indeterminate duration. So you find yourself employed with you in a contract of indeterminate duration. You may only terminate an employment agreement for cause, and the most used causes are gross misconduct. So pure misconduct is not sufficient for you to fire an employee. There should be a finding of gross misconduct, poor performance, redundancy, and conduct that have been subject to criminal proceedings. Conduct that have been subject to criminal proceedings need to have a bearing on the employment obligations of the employee. So if they are completely unrelated or do not in any way affect the reputation, the performance of work, and the ability of the employee to remain in the employment of employer, it may be difficult to terminate on those grounds. In addition to that, there are prescribed procedures that need to be followed in respect of each type of termination. For instance, the employee should be given the opportunity to provide his explanations, which normally takes a form of a disciplinary hearing, which is chaired by an external person most of the time. And for that matter, the employee should be given the chance of being assisted by a legal representative, by a trade union representative, or by an officer of the Ministry of Labour. So in addition to showing that the substantive requirements, that is that there is one of the causes, that the prescribed procedures have been followed, it is essential for the employer to show that the termination is made in good faith. In other words, that the employer had no alternative other than to terminate in the circumstances. So this is an additional requirement which is placed on employers. Now, we earlier on, Brian spoke about the possibility to have mutual settlement agreements. These are always possible under Mauritian law. In fact, the legislation makes specific provision for the possibility, even at the level of the disciplinary hearing or thereafter, for the employer and the employee to be able to come to a compromise in a mutually agreed exit. What you need to bear in mind, however, in terms of settlement agreements for workers earning less than 600,000 rupees annually, these have to be approved by an independent law practitioner, an officer of the Ministry of Labour, or a trade union representative. Finally, in respect of mutual settlement agreement, the employer, if the mutual settlement amount exceeds 2.5 million rupees, has a duty to deduct tax from the amount that is paid to the employee. Retirement, the normal retirement age in Mauritius is at 65. An employer cannot force an employee to retire before that age, but once the employee reaches that age, the employer may ask him to retire, but there's no absolute obligation for that to happen. Upon termination, for employees earning in excess of 600,000 rupees, there are no dues per se, unless there still are amounts that need to be paid into any statutory pension fund, or for employees earning less than 600,000 rupees annually in terms of annual leaves, for instance. It's a final word as well in terms of termination. If these are not followed, if these procedures are not followed, or if there is the causes are not proved, the employer typically becomes liable for severance allowance. So the quantum of severance allowance, the way in which it is calculated, is provided for under our statute. It is 3 months of remuneration per year of service once the employee has been employed for at least 12 months. Remuneration means all of that the employee was earning. So bonuses, all types of allowances are included for that purpose. In terms of any specific requirements for senior employees, there are none. They are equally protected as employees earning up to 600,000 rupees annually. If ever they hold directorships, that would be a matter to be dealt with under the Companies Act for the termination of a directorship. But the same situation as in South Africa would apply. If ever the directorship was a fundamental part of that person's employment, it would be perhaps unlawful to terminate the directorship prior to terminating the employment. So that would complete my presentation on firing.
Thanks, Shrivan, for a very detailed review. There are some questions from viewers as to whether the slides will be available after the presentation. What's going to happen is the presentation will appear on YouTube, and you will get a link. Everyone who has attended, or even if you didn't attend but had accepted, you'll get a link. So without further ado, the next segment is hiring and firing in Nairobi, Kenya. And Faith Chebet is going to take us through the requirements of this jurisdiction. Faith.
Thank you, Brian. I think the first thing that I'd like to just highlight is that in terms of the different types of employment, the different types of employment contracts, the classification of employees, and sometimes misclassification of consultants or independent contractors as employees is really the same pretty much as what has been presented by Audrey and Shrivan in Mauritius and South Africa. So there's a lot of similarities there. Some of the differences or uniquenesses that I'd like to highlight in respect of hiring in Kenya is that number one, you need to take a lot of care on the hiring process itself, starting from the interviewing stage. For example, what kind of questions are you going to be asking the interviewees? Some questions are actually not allowed to be asked or would be deemed discriminatory at the interview process stage. Whereas when an employee has already been onboarded, it might be lawful or permissible to ask those kind of questions. For example, you cannot or should not ask interviewees if they are married or if they have children, not necessarily because there's a direct prohibition in law, but because it might be deemed to be discriminatory if that person is not hired eventually. Whereas once you've onboarded the employee, you could ask these questions based on the fact that it's necessary for part of their employment benefits. The other thing on hiring process is with medical testing. We're just coming out of the pandemic, and there's been a lot of questions of, can we subject employees to medical testing, whether for COVID or other diseases? And it's a very yes and no answer. Yes, because depending on the role of the employee or the type of work that they're doing, you could ask them to take medical tests to just confirm that they are capable or in good health to take on the role. However, you cannot ask, or you're not entitled to require them to present the actual medical report because of medical confidentiality rules. So the most that you can do is to just get a report from the doctor to see whether this person is fit for work or not. But if the role does not necessarily require any specific medical tests to be conducted, like eyesight, then it might actually be discriminatory if you ask for medical tests to be conducted. On written contracts and the minimum terms of employment, these are also very similar with South Africa and Mauritius in terms of, you need to provide a written contract. And if someone works for more than 3 months without a written contract, it is presumed automatically under law that the contract is converted to a permanent employment contract. So that's the cautious thing you need to be aware of with contracts that are less than 3 months long and that end up with the employee working for more than that period. The next thing that's important at the hiring process stage is as well to make employees aware of the policies of the company that will be applicable to them. Once they are onboarded, it's important to let these policies to let them have these policies and for them to acknowledge receipt of the policies, because otherwise it might be challenging to enforce the policy if an employee claims that they were not aware of it in the first place. The other thing, Kenya has a huge expatriate community, and we need to ensure then that you have your immigration status, in check for your employees, and then to balance out the rights of employment or the terms of employment between the local, employees who are Kenyan citizens versus the expatriates. You can have unjustified differentiation in terms of employment where the basis is just the nationality or whether someone is an expatriate or not. So that's something to be cautious about, especially since Nairobi has a huge expatriate community with the NGO, with the UN headquarters here, with huge multinationals setting up here as well. The other thing at the hiring process is, on background checks. And I know Brian mentioned that we will have another webinar on GDPR, on data protection laws across the continent. You need to also balance out, data protection versus the right to privacy when you're conducting background checks. Yes, you can conduct background checks, but it is important to get this, notified to the employees at the application stage so that they are aware of that. And then the last thing is just on statutory notifications. You have to also get this going at the point of onboarding, like social security registrations and all of that. I think that's a good overview on hiring in Kenya. And I'm happy for us to move to firing Hillary. Thank you. So again, in terms of, process requirements, in terms of the fact that you need to have reasons for termination, you cannot just terminate at will. There's a lot of similarity in Kenya with the other jurisdictions there. However, the process is very specific, and the key thing is that it's not always, and in fact, it's not set out specifically under the Employment Act or under the statute. A lot of this has crystallized from decisions of the court. So you might think that you've been able to get a copy of the legislation online and you've ticked out all the boxes under the written law. However, a lot of the process requirements actually distill from various dispersed decisions of the courts. So that's one thing that's important to note about employment law in Kenya, is that it's very dispersed. The next thing as well that I'd like to highlight is that on the legal reasons for termination, it's not sufficient if you've got legal reason but you fail to follow the process. As an employer, you'll still be deemed to have breached employment law, and you'll still be deemed liable for unfair termination, even if it's a case as serious as gross misconduct, but you did not follow the right process. So that's a key thing to note as well. And I'd like to just make an interesting, I think, comparison with what Shrivan mentioned about Mauritius, that in Mauritius, you can't, terminate for misconduct that is not gross misconduct. In Kenya, you can actually terminate for misconduct that does not necessarily amount to summary dismissal, or does not necessarily amount to gross misconduct. The only thing is that you have to give notice, whereas for gross misconduct, you can summarily terminate without notice, but you still need to follow the right process for summary dismissal. On probation, there's an interesting, very recent decision of the court that has said that for probation, you still have to follow a very elaborate process of terminating during probation. So even if probation is 3 months long only, and that someone is not yet confirmed as a permanent employee, you can't just terminate them just because they're on probation. You can't just say that 3 months is over, so we're not confirming your employment. You have to give reason. You have to take them through a process, have a sit down. And that's something that I think employers are struggling with at the moment, because historically it's always been very easy to terminate during probation, but that's now changing. The other thing I'd like to highlight is on terminal pay. Just like Shrivan mentioned about Mauritius, in Kenya, for any amount of terminal pay, this will still be subject to income tax. So as an employer, you're entitled and actually required to withhold taxes and to remit that to the Revenue Authority. A few post-hiring points is you need to give them a certificate of service. You need to, get a discharge voucher from the employees. You need to maintain records for at least 3 years, because a claim can be lodged in court anytime within 3 years of the termination. And then there's no special distinction when you're firing senior employees versus other categories of employees. And in case of breach, you might be liable to pay up to 12 months compensation in damages. I think I'll leave it there for Kenya, and we can continue these conversations. Thank you.
Thanks, Faith. And, I had the pleasure not so long ago to spend a week with Faith and some of her colleagues in Nairobi. And what struck me is exactly what you were saying. You can read the legislation, but unless you understand the development of the law casuistically through the cases and how it's applied, you're going to probably end up in trouble. So it's true for Kenya, and it's true for a number of our jurisdictions, particularly in the African continent. I think that's a very valuable insight. And thank you for your insightful and punchy presentation. We're now going to move to Charles Visser, who is sitting in Windhoek in Namibia. And Charles is going to tell us a little bit about Namibian hiring and firing. Over to you, Charles.
Thank you, Brian. Yes, as a point of departure, I think it's a known fact that Namibia and South Africa share a legal history, and therefore a lot of the comments and information that Audrey presented earlier this afternoon is also applicable within the Namibian context. In the interest of time, likewise, Namibia recognized 2 types of employment contracts: a fixed-term contract and a permanent or indefinite period contract. similar to the South African concept, indefinite period contract or a permanent contract endures until such time that it is terminated by either one of the parties. And my colleague Raywood Tricora will talk to the termination of contracts specifically. Fixed term employment is recognized in Namibia. Fixed term contract is recognized in Namibia. It is regulated, but not as heavily regulated as the South African context. We have an amendment to our Labour Act, it's Act 2 of 2012, which creates a rebuttable presumption that all contracts are indefinite period contracts unless the employer is to provide a justifiable reason why a particular employee should be employed on a fixed term contract. I must say that although this presumption is in existence, it's rarely enforced or really implied. But it is there, and it's important to take notice of the fact that in Namibian law, all contracts, all employees are presumed to be permanent employees. It's important to as a caveat to keep in mind that the concept of tacit renewal in terms of a fixed term contract, if an employer allows an employee to continue employment subsequent to the termination date in a fixed term contract and continues to pay that employee his salary, that employee may very well claim the renewal, a tacit renewal of that fixed term contract of employment, or even may claim permanent employment. So it's very important that if a fixed term contract terminates, that the employer in advance renegotiate further terms or ensure that the employee gets employed. A further concept which must be kept in mind is that of a reasonable expectation when it comes to fixed term contracts. The more an employee is employed on subsequent fixed term contracts, the easier it becomes for the employee to claim that the employer has created a reasonable expectation of continued employment. So that's a concept when it comes to fixed term contracts that should be taken in consideration. Probationary periods are lawful, are applied in Namibian labour law context, and the termination of employment subsequent to the completion of the probationary period is indeed lawful. However, the termination must be preceded by a process rolled out by the employer in terms of which any performance failures must be identified, conveyed to the particular employee, counseling, training if necessary must be given to the employee to ensure that the employee or to assist the employee to reach the expected standard. And if that's not the case, then employment may very well be terminated at the end of the probationary period. Transfer of employees to Namibia, it's a concept that we're dealing with more and more, where foreign employers are keen to set up operations or to transfer or to deploy foreign employees in the Namibian workforce. That is indeed possible, subject to the necessary immigration rules and laws pertaining to work visas, work permits, and the Namibian government is generally very, very strict on due compliance with those regulations and legislation. It's important maybe here also to mention, like in South Africa, we have Affirmative Action Act, which requires employers to, when it comes to the appointment of employees, to identify and to appoint previously disadvantaged individuals, which are categorized within affirmative action legislation, and to create and submit annually a plan in an attempt to remove any impediments or obstacles in the employment of previously disadvantaged employees. Interesting concept that is also being considered within the Namibian labour context specifically is that of remote work, where an employee, being a Namibian citizen or a foreign employee, sits in Namibia and is effectively employed by an employer in Europe or in America. This is a context that this is a concept which the Namibian government is trying to address, and is currently working on a nomad visa, which will allow an employee to sit in Windhoek, but to work remotely for employer in any part of the world. This is still a work in progress. It will probably need to affect or to involve a change to our immigration legislation, but may very well be an interesting development in the coming months to keep an eye on. If and as it develops, we will surely convey that to you. Thanks, Hilary. And Brian, I'll ask Raywood then to deal with the firing part of this presentation.
Charles, just before you go, what's proposed in respect to that remote nomad visa, because that's quite exciting. What's proposed on tax? Do you know?
Well, that's $1 million question, Brian, because effectively there's certain requirements that earn at least $2,000 a month. Up to a maximum, it seems at this moment in time, to 64,000 Namibian dollars, and it seems that tax would indeed be payable under those circumstances. So interesting development.
Very interesting. So Ray Wood, I presume, who's joining us from Walvis Bay in Namibia, will tell us about firing quickly in Namibia. I presume the provisions, Ray Wood, are not too dissimilar to the South African provisions.
Yes, thank you, Brian. It is correct that it is very similar to South Africa and all the other jurisdictions that has been discussed. As an entry to firing in Namibia, we're operating from the premise that in our law, there exists a presumption of indefinite employment. Now that effectively means that it is deemed to be that all employees are presumed to be employed indefinitely unless there is specific contractual arrangements in place to speak to a different position. Now, where there is some such arrangements, you will look at what we refer to, and my learned colleague Charles spoke to it earlier, is the fixed term contract concept, where the contract will stipulate the period and the time, and it will also stipulate its exit. Now, exit in these contracts can either be by a fraction of time or by notice. Now, in the absence of notice, you will have what they refer to as payment instead of notice, or you will have a termination by redundancy or a dismissal. And finally, you would also have a negotiated termination. Now, Charles also spoke to the concept of probation. Yes, probation is allowed in our law. The purpose is basically to check whether the person who is employed is a fit for the result that is desired. And if they are not, you can terminate. But for you to be able to terminate, you must be able to provide reasonable grounds. Now, reasonable grounds must be preceded by the fact that you have given the necessary assistance, you have given the necessary training, and you have given the necessary guidance. In the absence of that, your grounds for termination of a probation period might amount to an unfair dismissal. There is a requirement that you should render at least the minimum tools to an employee to be able to carry out their obligations. Then, as far as indefinite contracts are concerned, you have it terminates either by a resignation of a party, or it terminates by death, or it terminates by dismissal. Now, dismissal would equate to what we're referring to in our heading as firing. And we normally, Namibian law does not use that terminology because it denotes that if you say firing, it means it's an active action from the employer for whatever reason. And the more generic question is, or term is termination or dismissal. Now, where you have a dismissal, it must be for a valid and fair reason. Now, that is a statutory requirement, and it's also followed by the fact that even if there is a fair and valid reason, it should be preceded by a procedural fairness before you can dismiss. Now, the fair procedure denotes that you should subject an employee to disciplinary hearings, and that they should be presided by presiding fellow employees or whoever, but they must bring an impartial mind, and that they must objectively assess the merits of the case before a dismissal can be considered to be fair and valid. Then you also have the second leg where it requires that it for fair and valid, it means that it must be substantively fair, that there must be a rule or a standard that has been breached, and that you have followed and given the party the necessary OD for them to also put their version before whoever is presiding, for it to not amount to an unfair dismissal. So the standard of that is required in this type is that you, on a balance of probabilities, that there was a fair and valid reason. So basically, then we move on to sickness and incapacity. Now, incapacity and or poor performance goes hand in hand. The employee is incapable of meeting their requirements or perform at work or their duties and this is not in itself a misconduct. It just simply means that either it is not equipped with the right skills, or there are medical reasons that leads to the employee not being able to render. You can terminate, but then you have to also follow a process. Then the concept of severance pay is also recognized in our law, and an employee is entitled to severance pay, and it also comes at termination, whether it's termination by death or whether it's termination by dismissal. The requirement is that there should have been a certain period of time of employment, and from that time you are able to deduce what is payable in terms of severance. That's basically, in a nutshell, termination in our law on a high end.
Thanks, Ray Wood, for a very informative presentation. We're now going to move to Accra in Ghana to speak to David Asidu. And everyone will know Ghana is a really growth area in the African continent. And I'm quite interested to hear this distinction, David, between employment at will in theory, but not in practice. So over to you.
Thank you, Brian. Let me start off by saying that labor relations are fairly cordial in Ghana, as among the courts and tribunals on the one hand, on the first hand, labor on the second hand, and employers on the third hand. The current main legislation on employment law has been in force for about 20 years now. And in this time, the labor courts have managed to drop the public perception of being pro-labor, and they are now seen as fair and neutral. Unfortunately, I can't say as much for the labor tribunal, which shares some overlapping functions with the labor courts. The employment law of Ghana comprises three main elements. I believe it's similar to what Faith said about Kenya. There is legislation, there is case law or judge-made law, and there is established practice. In the next few minutes, I'll try to give a bird's eye view of these three elements in the context of engaging and terminating workers. As has been said by other people, the other speakers, the three main types of terms of employment are indefinite, fixed term, and casual. I won't say too much more about that. I'll just move on to say that if the employment period is going to be more than 6 months, it's seen as permanent, and its terms must be reduced into writing. The elements that must be in the contract are partly statutory. So there are certain minimum provisions that must be in the employment contract. The term, the commencement date, remuneration, probation, not statutory, but advised to put it in working hours, job description, termination provision, paid leave, such like. It is unlawful to contract out of statute generally in Ghana, pretty much as in other common law jurisdictions, unless in contracting out of the statute, the employee or the worker who is the weaker party in the bargain is going to get more favorable terms than the minimal statutory requirements. For example, if the minimum number of paid leave days in a year for a worker statutorily is 15 days, and if Father Christmas employer wants to give a worker 365 paid leave days in a year, sure, that's fine, but not 10 because the minimum is 15. I'll move on and talk about the importance of having employment handbooks and terms and conditions of service. It's ill-advised to have a 2-page, 3-page letter which is signed by both the employer and the worker as the contract of employment. It's far more beneficial to have a handbook which contains policies, grievance procedures, termination procedures, welfare procedures, such like, because it makes the whole duration of the employment, including termination, easier and more streamlined for both the employer and the worker. If as an employer, your workers have joined a union, then similar terms will be in the collective bargaining agreement or the collective agreement. It's important to always have well laid out disciplinary procedures in employment contracts, because obviously that's the biggest battlefield as far as employment is concerned. The main principles are really fairness and letting the employee who has been accused of wrongdoing or misconduct have a chance to be heard. It's important to fill or have an HR role if you can, because it tends to kind of smoothen, if the HR person is competent and knows what they are doing, it tends to smoothen the relationship between the employer and the workers. And our experience is companies that recruit properly into the HR role tend to have fewer problems in industrial relations, and they tend to lose less in court, especially if it's coupled with getting proper legal advice. As I said, the law is not just in the legislation, it's also judge-made and established practice, and it's important to include lawyers. I will move on now in the interest of time. Next slide, please. So when it comes to termination, there are two main branches. There is termination with reason and termination without reason. Termination with reason is termination on notice, and it's established both by statute and case law that so long as the employment contract has a notice period by which either party, the employer or the worker, can terminate the contract, it's fine to just give the notice period and move on. So that's termination on notice, the easiest. Lately, labor unions and certain so-called labor practitioners who are not quite lawyers have been fighting to have it termination on notice without reason whittled down in terms of effect, but there is still termination on notice under Ghanaian law. Then there's termination with reason or termination for cause. Main examples being performance or inability, for example, illness issues, misconduct, economic and structural changes, which is redundancy. Redundancy has special rules under Ghanaian law. I'll highlight just two. There are notification requirements. You need to notify the worker or workers who are going to be affected. You also need to notify a certain government official known as the Chief Labor Officer. You have to give 3 months notice. So essentially at least 3 months before the redundancy is scheduled to take effect, you must let the affected workers or their union know, and the Chief Labor Officer. The practice has evolved where you can give them a week's notice, but you are going to have to pay 3 months' salary in lieu of notice. And there is also negotiations for redundancy pay. This is usually a very charged topic, because how are you going to tell an employer one moment that they are on on the kill list, and then the next moment you want to have cordial negotiations. So the trick is to pre-negotiate by putting it in the employment handbook or by putting it in the collective bargaining agreement exactly what the redundancy pay is going to be. The practice has evolved where the employee gets a certain number of weeks or months of pay for every year they have served as an employee. Generally, the lowest is 2 weeks for every year served, and the highest is 3 months. I'll move on to mutual separation. Mutual separation is provided for in statute, but the statute doesn't give too much stipulation on the point. So it comes down to negotiations. In practice, it's usually applied to high-level, management-level employees for reasons that have been mentioned by one of the previous speakers. But one of the most important reasons is that they have access to very confidential information, and the employer is interested in obviously signing a confidentiality agreement with them before they go. In all termination, the umbrella principle is fairness, and the courts or the labor tribunal will always look, no matter the circumstances, to see that the employer was fair to the worker. I thought I would mention that unlike it appears in other jurisdictions, there is a legal distinction between unlawful and unfair termination, and also unlawful and unfair dismissal as a subset of termination. Unlawful termination is termination which breaches a statutory provision, a provision of the Labor Act or a provision of the contract. So if an employer is supposed to terminate an employee only after giving 1 month's notice, and the employer gives only 2 weeks notice, that's unlawful termination. If an employer can dismiss an employee only after holding a disciplinary inquiry, which is done before a panel of 3, and the employer does hold the disciplinary inquiry, but before a panel of 1, it's unlawful termination, no matter how fair the sole panelist is perceived to have acted. Unfair termination, on the other hand, is termination which is tainted by issues of discrimination, e.g. racial, gender, age, so long as the person is over 18, or some kind of victimization, harassment, including where the victim complains about victimization or workplace bullying, and nothing is done by the employer, and then the employee feels that they must leave, which is really constructive termination. It's important to separate them because obviously they carry different implications for the reputation of the employer. Otherwise, as far as remedies are concerned, the remedies are similar. Statutorily, there are 3 main remedies. There is reinstatement, re-employment, and damages for unlawful and unfair termination. But in practice, because of the long-standing common law rule that the employment contract is not a contract of servitude, you cannot force a private employer, an employee, to remain in an employment relationship if one of them doesn't want to be in the relationship. So in practice, reinstatement as a remedy for unlawful or unfair termination is available only to a worker who works for the government or governmental bodies. As far as private employment is concerned, the only real remedy is damages. So it goes back to a question Brian asked, or a comment he made, that an employer can strategically terminate an employee, whether it's unlawful or unfair, knowing that they have the budget to pay the damages. There are no statutory rules around compensation for unlawful and unfair termination. It's within the peer jurisdiction of the labor courts and the labor tribunal. But there are certain things the courts look at which change from time to time, including the unemployment rate in the country, how difficult it is for certain levels of skilled workers to get employment, the age-old rule of mitigation. Within the economic climate, the employee must make a reasonable effort to find a new job. And the extent of fairness or unfairness that tainted the termination. So there are certain trends employment lawyers can glean from the practice of the courts from time to time. And these trends of damages which are awarded change from time to time. So essentially, damages could be as low as 3 months' salary, but they could go as high as 24 months' salary. Let me just end by saying that there's a creeping practice in Ghana where an employee may be terminated and their lawyer looks at the employment law and realizes that the employer has kind of done everything kosher according to the law and to the contract. What happens often these days is the employees' lawyers make it a pure human rights case where they basically say, whatever it is you did, which may be right in employment law, it's infringed a certain human rights provision in the Constitution. And then they make it a constitutional matter, which doesn't go to the labor courts, but goes to the human rights court as a way to get an unfair advantage. So the way to basically counter that is to go back to the umbrella principle of fairness. And I guess that would be it for engaging and terminating in Ghana. Thanks, Brian.
Thanks, David, and a very insightful presentation. Thank you very much. I suspect that many of the viewers are asking the same question that I would do, and that is, if you can terminate without any reason on notice, why on earth would you ever want to consider terminating on any of the examples of performance misconduct or retrenchment? Just don't give a reason and terminate on notice.
Would you like me to answer now? Or
if you could briefly, I'm sure that's in the minds of many.
So that's really correct. As a general rule, you have the right to terminate once you give the statutory or contractual notice. It doesn't really matter. But the truth is the courts will always lift the hood and see what's in the engine. So if there is a reason which can be proved, if a reason exists, but the employer basically tries to throw the rug over the real reason, and the court will subject it to scrutiny. So the employer who wants to use termination on notice must generally make sure that there is no hidden reason, a reason which especially might be tainted or might make the termination itself tainted by unfairness.
And I think, David, you'll agree that invariably there always is a reason.
While I agree that there is always a reason, the employee must be the one to prove the reason. So if the employee, if the employer has not dealt with a certain reason and takes the strategic decision to terminate on notice, it's going to, without more, it's going to be difficult for the employee to win a case in court. And it's our experience that properly guided by lawyers along the entire process, termination on notice it's easy for employers.
Sure. Well, thank you once again. I think that was a very useful exposition on Ghana. We're now moving to Rwanda, and Eustace in Gaga will take us through hiring and firing briefly in Rwanda. Eustace.
Yeah, thank you, Brian. In Rwanda, what should be taken into account when hiring? In terms of hiring for the employment of nationals, there is no specific restriction in terms of the eligibility, unlike in case of employment of a foreigner in Rwanda. So key aspect to consider if a foreign employer wants to employ a foreigner to occupy a position in Rwanda, the employer must first ensure that the position for which the employee is to occupy is on the demand list, the occupation and demand list, which is a list established based on the scarcity of some skills, which have been drawn up by the Ministry of Public Service. So that's one. You need to ensure that you have this position is on the demand list. Secondly, foreign employer may be allowed to work in Rwanda on secondment or in case of transfer in Rwanda. And also another aspect to consider is if the employee position is not on the demand list, then the employer will have to conduct market testing, which is a procedure carried out by the employer in case they didn't have any qualified Rwandan. Now, the occupation demand list, this is a list of occupations which are in short supply in Rwanda, and they range from professional services, management category, professional category. And if you have this a position which is on that list, then you could be allowed to hire a foreign employee as a Rwandan employer. Another aspect to consider is foreign employee can be employed in Rwanda on secondment if the secondment is allowed and there is an agreement that has been signed by Rwanda and another country. And in the framework of that agreement, there is a list of certain positions which have been agreed. In this case, in case of, let's say, an agreement which Rwanda has ratified and which is about the movement of labor. In this case, for example, the case of East African Community, the East African Common Market Protocol, and other agreements which might be bilateral agreements. So in that framework, an employer can recruit or can hire a foreign employee in Rwanda through that. And another aspect to consider is if there is no qualified Rwandan that the employer has been able to get on the Rwandan market, the employer is allowed to conduct a market testing whereby they have to advertise for the position for at least 15 days. And after that, after that, they have to conduct the test, they examine the applicants, and once they fail, they make a report to the organ in charge of immigration. And the employment will only be allowed upon a recommendation from the organ in charge of immigration, which is the Director General of Immigration and Immigration. And that report, based on that, then the employer can recruit a foreign employee in Rwanda. So this is, in a nutshell, what entails in terms of recruiting or hiring a foreign employer in Rwanda. For national, there's no issue, there's no restriction at all. As long as the employee and the employer agree and the employee meets the requirements or the job profile, there is no other restriction. The restriction applies only to foreign employees. In case of foreign employees, in this case, the employee must, the employer must ensure that the job is on the occupation demand list, or if there is no qualified Rwandese, then they have to conduct a market test to get a Rwandese. If they fail at that time, then they're allowed to recruit, but again, upon a recommendation from the organ in charge of immigration. So once the eligibility aspect has been taken into account, then the types of employment contract that we have in Rwanda, unlike in other jurisdictions, of course, there is a slight difference here in Rwanda. In Rwanda, apart from the fixed term and permanent employment contract, we do not have, the labor code does not provide for other types of contracts, such as casual worker contract or independent contractor. So these, the independent contractors are subject to separate agreements, which is signed or concluded as per the general contract law. But in terms of the Labor Act or the Labor Code, we do only have the two types of employment contracts, fixed term and employment and the permanent employment contract. Now, for fixed term, unlike in other jurisdictions where there might be some limitation in terms of how many times you can renew the fixed term, in Rwanda, there is no limitation. You can have a fixed term renewed up to many times, depending on the will of the parties. And there is no such thing that if you exceed, if you renew for 2 or 3 times, then that would be deemed to be a permanent employment. So we do not have such a provision, a requirement in our labor laws. So the fixed term is upon the duration is upon the will of the party, is based on the will of the party, and they can renew that fixed term contract as many times as possible. The employment, permanent employment, so this is an indefinite period contract, and is also provided for under the Labor Act. So now, when dealing with or when preparing or negotiating the employment contract with the employer, the employer should ensure that there are some statutory elements that have to be reflected in the contract. And these are clearly defined in the ministerial order implementing the Labor Code. And so when you draft the contract, you should ensure that these are taken into consideration. And there are many of them, including the overtime, remuneration provisions, overtime, procedure for termination of the employment contract, the reporting lines, the address, the identification of the employees. So there are various elements that must be taken into account in the written contract. So next slide, relating to firing. Firing in Rwanda, the law does not allude to the aspect of firing, but instead the termination of the contract or dismissal. Now, grounds and procedure for employment termination, any termination of the agreement or employment contract must be based on legitimate reasons, and it must also follow a prescribed procedure. Now, under Rwandan law, there is no definition of what is a legitimate reason. However, there are factors that should be taken into account that would be considered as a legitimate reason, including misconduct, gross misconduct, economic, technical reasons or technological transfer, and long-term sickness. For misconduct, of course, the employer, the onus will be the employer to prove the wrong done by the employee before terminating the employment contract. And also that should be subject to a proper procedure before you terminate. Even if there's a misconduct, the employer should issue a notice for terminating the employment contract. And if they fail, that will be considered as unfair termination of the employment contract. And then they'll be subject to payment of damages. So there's also another reason for terminating an employment contract, which is gross misconduct, in case the employee has done an act of gross misconduct. And here, gross misconduct are acts which are defined again in the ministerial order implementing Labor Code. And these are clearly defined. So if you want to terminate based on a gross misconduct, you only have to take into account those acts which are prescribed under the law. Other than that, that will be considered as unfair dismissal. So however, for employers who, depending on the nature of their business or their operation, they can have additional acts which they can be construed as gross misconducts. However, they must be approved by the ministry in charge of labor. So if you have an internal policy in place or and no regulation in place, but that which has not been filed with the Ministry of Public Service and Labor for approval and containing additional or other elements which are not in the ministerial order, those will not be regarded as gross misconduct, and any reliance on such acts to fire or to terminate the employment contract based on gross misconduct will be regarded as or be construed as unfair dismissal. So another aspect is economic and technical reasons or technological transfer. In this case, this is also a legitimate reason. But however, in this case, the labor inspector must be brought on board in this process, including as well the employees, staff representatives, to have them to have their say and to involve them in the entire process until there is termination of the effective termination of the employment contract. Another ground for termination will be long-term sickness. If there's a report of medical doctors, a report from recognized medical doctors, and these have in the report, it is indicated that the employee is unable, is no longer able to perform their duties because of the reason, due to the reason of sickness, then the employee can be terminated after a 6-month period of long-term sickness. Now, in terms of procedure, again, procedure depends on the ground for termination. If, for instance, in case of economic, technical reasons or technological transfer, in this case, the procedure seems to be, procedure is lengthier than in the other cases where in case of misconduct, the employee just had to issue a notice and provide what the contract provides. And that's it. So there's no requirement to inform the labor inspector, unlike in case of termination based on economic reason. So now in terms of terminal benefits, of course, must be provided and granted to the employee in addition to the certificate, work certificate. And terminal benefits here, most in case of termination, you should ensure, the employer should ensure that if the termination is unlawful or unfair, then the termination will be subject to that process, or the employer will be subject to payment of damages. And the damage in the case of unfair dismissal can go up to 6 months, between 3 months and 6 months. And to some extent 7 months if the employees has worked for more than 10 years in the same company, in the same enterprise. But generally, the damages that are granted range between 3 months, the equivalent of 3 months, 3 times the salary of the employee, monthly salary, to 6 month salary of the employee. So unlike in other jurisdictions, in Rwanda, we do not have the provision of restatement to reinstate the employee. So we don't have that remedy under Rwandan law, where in case of termination, should the court find that the employment was unfairly terminated, we do not have in our laws that requirement to reinstate the employee. So the remedy should be only, or the relief sought by the employee would be only seeking damages before the court. Other than that, there is no other remedy in terms of unfair termination. So I think in the interest of time, Brian, back to you. Thank you very much.
Yeah, thanks, Eustace, for a very comprehensive summary on jurisdiction. I think perhaps isn't as familiar to most as many others. Before we go to Q&A, we now move to Kampala, Uganda. Last but certainly not least, Rachel Masuka, who will briefly tell us about hiring and firing in Uganda. Rachel.
Thank you, Brian. I'll be covering the Pearl of Africa, Uganda. So starting with hiring, it's not too complicated to hire in Uganda. And there are a number of options that an employer would have in terms of the types of contracts that they can choose. The first being the fixed term contract, which is the contract with a predetermined end date. And these are typically used where the employer does not want to make a long-term commitment to the employee, say for instance, because the business sustainability is not yet certain, or the employee is being brought on board for a specific short-term role. But those contracts can be renewed from time to time. The second type is the indefinite term contract, or the open-ended, which, as the name suggests, does not have an end date, but may be terminated, of course, on the terms of the contract or according to labor law. These are obviously preferred by employees because they give a sense of job security. But on the employer side, they also take away the burden of having to monitor, expiry dates or renewal dates. So that should be taken into account. The third aspect is casual workers. This is a concept that is recognized in Uganda. It is employing somebody to work for you on a day-to-day basis. So it's really more common with odd jobs, like bringing people to offload goods or to harvest and things like that, really short term. And what one should be mindful of here is these contracts cannot exceed a period of 4 months. Otherwise, the employee will be deemed to be a full-time employee and entitled to all benefits. Now, away from employment, the employment-employee relationship, an employer could also consider hiring an independent contractor. This person would be deemed to be completely separate from the company. They are responsible for their own taxes. They are not paid any employee benefits. And the test for this, just to make sure that the person will not be reclassified as an employee of the company, is the test of control. So what is actually happening on the ground in terms of where is this person working, who is providing the materials that they're using, who's giving them instructions, and to what degree is the employee involved, or rather the employer involved in instructing this individual, are things that would be taken into account. So those need to be monitored carefully. On the employment-employee relationship, there is a requirement under Ugandan law for the employer to give the employee written particulars of the contract or the terms of employment. And these particulars must include the commencement date, the names of the parties, of course, the pay that will be applicable, the hours of work, and so on and so forth. We do see other common provisions in the contracts, even if they are not mandatory. And these include probation. So most employment contracts are going to start with a probation period. And our law allows for initially up to 6 months, but with the consent of the employee, that 6-month probation could be extended for up to another 6 months period. We often see restraint clauses, those would be permitted, confidentiality clauses, and of course, notice periods that would be applicable must also be contained in the contract when you're hiring. Hilary, could we move to the next? Yes, so now where I said that hiring is not complicated, firing can be very complicated or can become complicated if it's not followed by the book. Under Ugandan law, you need a fair reason to terminate the services of an employee. There has been a bit of debate around this issue because our previous Employment Act permitted termination on notice without a reason. But after 2006, that law changed and a reason will be required now. even if some people still try and say that you can get away with it. But we do not agree with that, and our courts have come out clearly to say that you need a reason. You must also follow fair procedure, and the procedure to be followed depends on the reason for the termination. Failure to follow proper procedure will lead into the termination being deemed unfair. So you want to be very careful about how you go about this. I will look at just a few reasons that could be considered to be fair, starting with misconduct or poor performance. And I'll look at these together because the procedure to be followed is the same. So if an employer is considering firing an employee on grounds of misconduct or poor performance, they're required to hold a hearing and to inform the employee that they can attend the hearing with a person of their choice. That person need not be a fellow employee, it could be anyone at all. The hearing must be before an impartial committee of the employer, and the reasons must be stated clearly to the employee as to why they are being considered for termination. The employee must also be given time to respond to whatever allegations are put before them. Where the reason is misconduct, would also expect that an investigation has been conducted prior to the hearing. The hearing, we get this question a lot, what kind of hearing should it be? Do we need to have lawyers present and the like? Our courts have come out clearly to say that this is, it need not be a mini court. It is an informal hearing. The parties must just be given an opportunity to be listened to. And so that's what must be followed. So another reason that would be deemed fair is ill health or injury that prevents an employee from working for more than 2 months, which is the point at which the employer would then consider termination, and they would then need to give notice and terminate according to the terms of the contract. The third one I'll look at is operational requirements. If an employee or if an employer needs to restructure their business for whatever reason, it could be a merger, it could be that they are reducing on the size of their operation, this would be a fair reason, and the process to be followed depends on the number of employees that will be affected. If you're looking at terminating 10 or more employees, then there are 2 levels of engagement that are required by the employer. The first one is with the labor union, if there is a labor union that represents the employees. And the second one is a notification to the labor commissioner. And each of these have the dates that must be followed, or timelines that must be followed. The notice to the commissioner has information that must be included, for instance, how much pay will be given and when it will be given. Now, all of these procedures would apply even for senior level termination. There's no distinction made in law. Obviously, if the contract provides for something different, then that would need to be checked and complied with, provided that it is not below the minimum required by law. If that senior person is a director, then you'd need to also look at the company law provisions as regards removal of a director. Now, with termination, you'd be looking at giving notice for whatever your reason of termination is, except if it's a summary dismissal, which would be justified for gross misconduct or for if the employee has fundamentally breached their employment terms. You'd also not expect notice to be given where a fixed term contract has naturally come to its end, or where a person reaches the agreed retirement age. But again, you need to check whether the employment contract provides for otherwise, and follow that. There are situations where we've been asked whether the parties can simply enter into a mutual separation agreement. And it's common, especially when there's a redundancy taking place. We would advise against it if there's actually a reason, like misconduct behind the termination or the separation, because I think David used the term lifting the hood and looking at what's under it, because even if the separation agreement is signed and that employee came back to court and made a complaint, the courts would listen. They would not turn the employee away simply on the basis that they signed the separation agreement. So again, that needs to be looked at carefully, and the circumstances leading to that separation agreement should be considered. The dues that will be payable on termination include salary up to the last day worked, the notice, which would usually be expected, or payment in lieu of notice if the employee consents to that. You would be expected to pay for all outstanding leave days, and that's for the whole duration of the employment. And then if there are any overtime dues that are unpaid, or any other benefits that are provided by the contract, then those will be payable on termination. As regards unfair dismissal disputes, and what our courts are likely to award, I'll start by saying that our courts are very employee friendly. So you don't want to go there lightly. But we've seen awards being made of, I think the highest we've seen is in the region of R1 billion, which is about $270,000. And it's not necessarily based on the number of, or rather the salary of the person. So it's really at the discretion of the court. We do have the remedy of reinstatement, but our courts are very hesitant to order that because of just how impractical it would be for the parties after spending months or years in court to go back and work together. So we very rarely see that. One of the interesting ones we're seeing coming out more now in our courts, one of the orders is for the employer to pay the salary loan of an employee who has been found to have been unfairly terminated. And we're really hoping that this will be overturned because it just doesn't seem to make much sense, what the connection would be. The employer has not guaranteed the salary loan after all. But those are some of the drastic measures that we've seen come out of the courts. And so that just emphasizes the need to follow the procedures properly. I think that's it for me, Brian. Thank you very much.
Well, thank you, Rachel, and thank you for such a comprehensive review. We've gone well over time. There are 4 questions or so, so I'm going to ask the panelists to answer them briefly. If there are any questions arising out of this, you can get hold of either myself or the panelists directly, and we will certainly try and respond. The first question, or the first 2 questions, are South African questions, and Audrey, if you could please address them. One of our attendees has asked, if you have an employee on a fixed term contract for a good valid reason and the contract ends, are you then able to enter into another fixed term contract with another employee in the same role, i.e. same role but different employee? Audrey?
So, in law, there's always a simple answer and then there's the more complicated answer. So the short, simple answer is yes. The more complicated answer is I would then be questioning why this is a fixed term contract. Because as I said previously, normally you'd have to have a justifiable reason for fixing the term of a contract, which means that work's going to come to an end at some point. So I would question why you need someone new in the same role, and the employee that was previously in the role may well have an unfair dismissal claim because they may well be able to demonstrate that they had a reasonable expectation that their fixed term contract would be renewed if you still needed someone in that role.
Yeah, or that you fail to re-employ them. I mean, I think this, as you say, Audrey, highlights the importance of looking at the underlying raison d'etre in South Africa for the fixed-term contract. They're not just to be entered into for the taking. There has to be a proper justification. Otherwise, you run the real risk it'll be treated as an indefinite period contract.
Agreed. And then the second question, while I'm on, Brian, sorry, I think that was also directed to you.
Yeah, do you want to just deal with that?
Sure. So the second question is whether from a South African perspective, if there are fixed term contractors that are employed for longer than 3 months, does the designated employer have to declare the stats of such fixed term contractors as temporary employees or permanent employees when presenting the EE stats to the Department of Labour? So as I understand it, this question relates to reporting on your, submitting your employment equity report to the Department of Labour. And in that report, you've got to report on the progress that you've made in achieving your targets across all occupational categories. One of the categories on the report is temporary employees. So I think the question would be whether, it's not just someone who's been there for longer than 3 months, but if you've got a justifiable reason for employing them for longer than 3 months and they're not deemed to be an indefinite period employee, I would still report on them as as a fixed term employee. But if you know that in reality they are going to be deemed to be indefinite period employees in terms of Section 198 C, I think it is, of the Labour Relations Act, then I would report on them as indefinite period employees. And of course, here we're only talking about employees that earn below the threshold.
Excellent. And then the next question is to David Sidhu in Accra, Ghana. And David, the question's quite interesting because it has to do with termination without reason. And some viewer who's looking at securing his employment rights well in advance. The question is, with regards to termination without reason, and it is termination with notice, as an employee with scarce skill and to protect my interests, is there any maximum notice period for termination without reason? i.e., can I include in my employment contract a notice period of a year or 2 years so I get paid in the interim should I get terminated without reason? So to deal with the termination without reason, can we put a very long notice period in?
So there is no maximum notice period, but there is a statutory minimum notice period. Generally, for fixed term contracts, it will be 2 years because the statute says, sorry, two weeks notice, because the statute says for contracts under 3 years, the minimum is 2 weeks. For indefinite term contracts, the statutory minimum period is 1 month. So there is no maximum. If you are a skilled negotiator as a worker looking to be employed, and you can sell ice to the Eskimos, or shall I say sunlight to the Africans, and you can get 1 or 2 years, kudos to you. But I haven't seen anything more than 3 months. I haven't seen anything more than 3 months.
Well, just a follow-up question from me, David, because in South Africa, the problem would be that there has to be reciprocity of notice period. So the employee's notice period has to be same as the employer. Is that the same in Ghana, or can you have differential notice periods?
As a general rule, it must be the same. It's mutual. So if it's 1 month, it's both for the employer and the employee.
So the employee negotiates 2 years. The employer will also have to give 2 years notice.
Yes, which really doesn't make sense for an employee who's found a better job and needs to hop quickly.
Exactly, he'll have to negotiate himself out of the notice period. So I think it's a clever question, but it's perhaps not as easy to do in practice as first appears. Thanks, David. I think that answers the question. The next question's a fairly substantial question, and it's a question to my partner, Charles Visser in Namibia, from a former partner of mine, Ruben Philander. Charles, I've spoke to you about the question. Maybe you'd just like to explain it. There's 2 parts.
Yes, thank you, Brian. Thank you, Ruben, for participating and attending. Ruben poses two two questions. Well, the one is a comment. I agree, Ruben, that when it comes to probations and this pre-termination evaluations by an employee during that probation period, that must also extend into any extended probation period. So if the probation period is extended, there's still a duty on the employer to make sure that all the necessary support is provided to the employee in respect of training, counseling, and the likes before the termination is extended. Naturally, the more senior the employee is, you don't expect your managing director or your financial director to be trained beyond reason and norms. You expect those employees to have certain skills and be able to do the job. But as a general proposition, Ruben, I agree with you. You're right. The second question posed by Ruben is payment of severance, specifically in respect of the dismissal of an employee. Severance is dealt with or regulated by Section 35 of our Labour Act. And as a general proposition, severance is payable when an employee is dismissed. The proviso, however, is that if it's a fair dismissal, that's procedurally and substantially fair, severance is not payable. That is the position. Ruben, I had a discussion with the special advisor to the Minister of Labour during the course of last year, and it seems there is a effort, or at least discussions, to amend the Labour Act to make the payment of severance applicable in all instances, including resignation by an employee. So severance is not payable when an employee currently resigns, but it seems there are thoughts to amend the law accordingly. I hope I address your concerns or your questions.
Thanks,
Thank you, Brian.
Well, that really brings us to an end. I think it's these are fascinating issues, and fascinating issues right across the African continent. I'm sure you'll agree with me in as much as there are similarities in many of the jurisdictions, there are very important distinctions, local practices and the like, and issues that are not apparent from the legislation. And it was very nice talking to my colleagues in country and who understand all the employment laws and getting this insightful review. So thank you for joining us. I also thank you for your forbearance. We have gone way beyond the timing we thought, and we're looking forward to running the next webinar, which I think is likely to be a review of restraints of trade law in the African jurisdictions that presented tonight, and that should be very, very interesting because a lot of our clients rely upon restraints of trade. So thank you, and we will undoubtedly reconnect soon. Thanks everyone for joining. Bye-bye. Bye.
Bye. Thank you.